Oh, yeah.
Hey, that's something everyone can enjoy.
You for 6 minutes, please. Go ahead.
Well, good morning, Commissioner. I have questions for you about legislation Bill C-8. There have been a pretty broad chorus of voices that are concerned about the sweeping and secret powers that cabinet ministers would have over the internet access and telephone access for individual Canadians, the power to secret powers to seize private data without warrant and conceal those actions from the public. So would secret orders to disable an individual's telecommunications access be inconsistent with the principles of the Privacy Act, and if so, why, sir?
Thank you for the question. So in the last Parliament, I appeared on Bill C-26 and talked about some of these issues when legislation aims at giving more power to the state to protect infrastructure and to disable and to take certain steps. And as Commissioner, I've always stated that privacy is not an obstacle to public interest. It's not an obstacle to national security or to strong economy. But we need to make sure that by protecting national security, we're not doing so at the expense of privacy. And so in cases like this, what I said to the committee was that we needed to put in the legislation a criterion on necessity and proportionality, making sure that the exercise of those powers is going to be tested from a privacy perspective to say, is this necessary? Does it achieve the result for which it's been put in place? And is it proportional? So that's the substantive element. And you mentioned secrecy. In certain instances, secrecy is necessary, but it should be challenged, and there should be ways for some reports to be made to appropriate authorities. It doesn't have to be necessarily that may make it public, but reports to my office, reports to a national committee of parliamentarians, or other means.
And so in your review of this proposed legislation, does it check all of those boxes?
Well, I will be waiting to testify on C8 when called, and we're reviewing that very, very carefully. But there is, I think, more to be done in terms of the reporting mechanism and the necessity and proportionality.
I would say for sure that there's more to be done. This bill proposes to let the government secretly cut a Canadian's phone or internet service, and the cabinet minister would have the power to issue the order, would prohibit that the existence of the order to cut that service prohibit its revelation, and that the order even existed, which would, of course, eliminate the ability for anyone, including you in your role as commissioner, to have any oversight whatsoever. Isn't this a direct circumvention of the act over which your mandate is concerned?
Well, that's why, again, to make sure that we're not making it more difficult to raise rights and to protect privacy, reporting to appropriate authority, even if done in a confidential manner, is something that I recommend. Making sure that there is ability for my office to be aware of it, to be able to raise questions. In some instances, a report to Parliament is appropriate. A report to committee is appropriate. And so this should be part of the discussion and the assessment to say, what type of reporting is there? Is it enough? But certainly, in my view, there should be confidential reporting to some authority who would be able to raise questions about it.
Currently, that doesn't exist in the legislation. What you're describing, what you describe as essential, is not included in the legislation. Bill C-8 lets a minister compel data without judicial oversight. So this also creates a risk of a parallel system where Canadians' personal information, their personal data, can be seized in secret, again, with no redress by individual Canadians or by your office. Isn't this antithetical to the type of system that your office has been designed to protect?
Well, if My office is not aware of something happening. Of course, we can't raise questions about it. We can't assist Canadians. And so I think, again, there will be instances where making something known to the public may not be appropriate, but we should challenge a claim to absolute secrecy. We should make sure that there's appropriate reporting to the appropriate authorities and that there is an appropriate means to raise questions.
Right. Of course, if your office doesn't know that the law is being broken, then I guess the government's contention is that they haven't broken the law. Do you think that a vague standard like, quote, any threat, which is the term used in the legislation, undermines safeguards in the Privacy Act, such as the requirement that collection or use must be necessary, proportionate, and authorized by law? Well,
we've advocated in the past, and as I say, I expect to be called specifically on this bill to address it, but as a general proposition, I recommend a necessity and proportionality to be in the legislation made explicit so that there's a strong test. Yeah.
Okay, thank you, Mr. Barrett. Mr. Dufresne, Monsieur Sarr.
Oh, yeah.
Second round. Mr. Cooper, you have 5 minutes.
Thank you, Mr. Chair. Thank you, Commissioner. Commissioner, the charter jurisprudence based upon the Supreme Court's 2014 Spencer decision and the more recent 2024 Bykovitz decision is clear. Access to personal data requires prior judicial authorization, correct?
Yes, those were the findings of the court.
Okay, and looking at the Bykovitz decision, the court confirmed that subscriber data is, quote, the key to unlocking a person's identity and online activity, and based upon that, the court affirmed that even IP addresses attract a reasonable expectation of privacy and therefore cannot be obtained without a warrant, correct?
Well, that was a finding in that case. Again, the argument was this information is not specific enough, so we can ask and obtain it. And in the court really found that we can draw so much about individuals with these types of data points, and so in that case found that a warrant was required.
Okay, well, thank you for that. And to satisfy, in order to obtain a warrant or a production order in this type of context, the standard that would have to be met is reasonable belief. Is that correct?
Reasonable belief, there's some instances where under the law it will be reasonable suspicion. So I think that is where some of my recommendations are, to the effect that when we're talking about sensitive information, it should be reasonable belief. We should have a more rigorous standard to assess that.
Okay. So with that in mind, I want to ask you some questions about parts 14 and 15 of the Liberal government's Bill C-2, buried within the so-called Strong Borders Act, are sweeping new powers to government agencies to demand Internet subscriber data. For example, Section 487.0121 of the Criminal Code, the proposed section, would allow police and CSIS officers to demand customer information from any company providing public services, including banks, telecoms, and social media, on a mere suspicion without judicial authorization. Have I got that right?
Right.
Okay. So in terms of understanding the implications of what that section would enable law enforcement to do, law enforcement, for example, could compel a bank without a warrant to reveal whether an individual is a client of a bank, how long they've been a client for, where they have accessed banking services, and provide the name of any person who has provided services to that individual. Is that fair?
I don't have the section in front of me, but that sounds right.
And it would provide warrantless access to subscriber data, including IP addresses.
Again,
right?
Sounds right.
That sounds right. And so it would seem to me that completely eviscerates the standards set out in Spencer and in Bykovitz, right?
Well, it modifies it. Parliament can do that. The question is it necessary and appropriate? And so when we look at this, we ask questions about why is it suspicion and not belief? Is it rigorous enough? Is there enough reporting? These types of questions.
Yeah. But it raises serious privacy implications, does it not?
It has privacy implications. You're making it easier to obtain the data.
And do you have any concerns about that?
Well, again, I'm giving in advance the testimony that I'm going to be given to the committee when called on that specific bill. But certainly, once what we've seen so far is we would have preference in it being reasonable belief as opposed to reasonable suspicion in some of those aspects because of the sensitivity of information. And so there are areas where the standard, in my view, should be higher.
And the standard would be higher, in your view, in this context?
Standard of reasonable belief as opposed to reasonable suspicion.
Well, and what about the ability for law enforcement to access sensitive personal information? I think you would concede the information that we're talking about here is sensitive personal information. You'd agree with that?
In many cases, it will be. In some cases, it may not be. But my point is, if we're talking about that sensitive information, the threshold should be higher. There's appropriate places for suspicion, but reasonable belief when we're talking about sensitive information is critical.
And
Sorry,
okay.
Mr. Cooper. That's 5 minutes, just a little bit over, not much. Thank you, Mr. Dufresne. Ms. Church for 5. Go ahead.
Thank you, Mr. Chair.